Welcome back to another episode of The Lawyer You Know, and today we're doing our Q&A on the Lori Vallow Chad Daybell case. We're going through the questions you had, and I'm doing my best to answer them. I'm not able to get to all of them, especially the questions where people asked, why did they kill her kids and not his? How did this end up in his system? How did this happen? Why did they do that? I don't know why they did a lot of what they did, so I'm not going to have answers to those questions. I tried to pick the questions that were pointed to legal questions that I'm able to answer and shed some light on for you all who are listening to this. Thank you for your questions. Feel free to bring more. I'm going to continue on with this case if there's interest from our community, from the people that follow this channel and subscribe to our page. On that note, don't forget to subscribe to this channel, like this video, so you'll be involved in all the future videos and I can put out the content you want to watch, you want to listen to. So let's jump into this Q&A. Number one, I want to know if Lori Vallow will be held accountable if she's not competent as she's deemed now. Well, Lori Vallow was deemed incompetent to stand trial, which in Idaho means you cannot understand the charges or the penalties brought against you, and you can't assist your lawyer in your defense. Very similar to Florida if you're not found competent in that situation. There are some major differences in Idaho that we'll get to eventually. So, when we talk about whether or not she's going to be held accountable for what she did, just because she's found to not be competent at this time to stand trial doesn't mean that's going to be forever. In fact, it seems she is going to be continuously reevaluated until she is competent to stand trial. She was put in a restorative program that I believe was 60 or 90 days of mental health counseling that's supposed to help restore her and help her to be competent eventually to stand trial. But what's really interesting about this question is I think it surrounds the insanity defense. Will Lori Vallow have this not guilty by reason of insanity defense at trial like we know so much about here in my home state of Florida? And the answer is no. Idaho is one of the states that does not have the not guilty by reason of insanity defense for criminal defendants in this situation. This went all the way up to the Supreme Court of the United States, and they had to decide whether or not that was constitutional, whether or not that was okay. They decided in a split decision that it was okay for Idaho to not have that type of situation where you are not guilty by reason of insanity. But Idaho does have this situation set up to where you can plead that you did not commit these crimes because you did not have the necessary mens rea. That is mental state. You didn't have the necessary mental state to commit the crime. And the Supreme Court actually sets out some scenarios as to how it would flip the situation. So I'm going to give you those scenarios because I think they're a great analogy and illustration to help you visualize and understand exactly what the difference is between not having a not guilty by reason of insanity, but having a I don't have the proper mens rea to commit this crime. Not guilty by reason of insanity means basically in Florida that you had no clue what was going on. Your mental state was totally screwed up. You were seeing demons, you were seeing ghosts, whatever it may be. You didn't understand what was going on. You snapped in that moment. You had no clue about any of your surroundings, the consequences of your actions, what you were doing. That's the insanity defense in a gist. But the way it's set up in Idaho, the Supreme Court gives these two scenarios to show differing outcomes. Case number one. The defendant believes that the victim is a wolf, and the defendant thinks he's hunting a wolf and shooting a wolf as a hunting exercise. So when he kills that wolf, he believes in his head he just killed a wolf and not a human. Not guilty, because he did not possess the mens rea or the mental state to meaningfully, purposefully, premeditatively kill a human being. Not guilty in that situation if those are the facts that are proven. But in scenario number two, if the defendant believes that a wolf is his master and this wolf is telling him to go kill that human victim, so the defendant says, okay, grabs his gun and goes shoots that human victim because the wolf told him to and the wolf doesn't really exist, he's guilty of murder because he possesses the mens rea to kill that human victim. He possesses that mental state. He premeditatively, purposely killed that human, even if he did it because he's a little cuckoo or has, some voices in his head telling him what to do. Okay, so that is a big difference and distinction. What do you think about that? Do you think it's fair? Both defendants imagined a wolf in their scenario, but what part the wolf played in their story made all the difference in the world and all the difference in whether or not they were guilty or not guilty based on how the law is in Idaho. So let me know what you think about that. Let me know if you understand it or if it's too confusing. But I want to know, do you guys think that's a fair distinction there as how the mens rea works and whether or not you possess that proper mental state to be guilty of a crime like murder in Idaho? Question number 2. I've been filled with questions since the kids went missing. I'd like to know when they did the evaluations to figure out if she is competent enough. Was it right away or just recently? Was Chad evaluated the same way and at the same time? What makes him able to stand trial and not her at this point? How long has she been deemed unfit, and what qualifies someone to be considered unable to stand trial? So Lori was originally evaluated in March of this year. And like I said, she went into that program. It was either 60 or 90 days. She's going to be reevaluated. Chad, I assume, was evaluated at some point, but not deemed unfit or not competent to stand trial. So there was a difference in their evaluations. And there can be a lot of different reasons. Not everybody is evaluated. So maybe they didn't feel the need to evaluate Chad, but something about what Lori said and how she explained this process, or her lawyers or a loved one or somebody said she needs to be evaluated. It can't even be the court sometimes that says she needs to be evaluated. And in this case, we know that certain quotes she was making make you understand why she was evaluated to see if she was competent to stand trial or if she had some mental issues. She thought her children had been inhabited by evil spirits and had turned into zombies. She thought she was a god and she could choose who the 144,000 were that were going to come to heaven with her. They had these cultish religious beliefs that, like many cults, take certain things about the Bible, twist it into whatever this cult believes, and then take it to the nth degree that they're now gods and other people are zombies and there are evil spirits that they are allowed to kill or are mandated or it's their mission to kill them. So she was kind of along those lines saying things like that. Therefore, they thought it was necessary for her to be evaluated. When she was evaluated, she was found not competent to stand trial, meaning she does not understand the charges and consequences against her, and she can't assist her defense attorney in her defense. Question number 3. I just can't understand how she could go so long with her children being missing and not get arrested sooner. So there's a bunch of different reasons for this if you know the facts of the case. She was telling law enforcement that they were in Arizona with family. They were here, they were there, they were all over the place. So it took time for law enforcement to investigate where they were. And again, once law enforcement in Arizona went and looked for them, didn't find them, that put up more red flags. But they don't just automatically know that they're dead at that time. They still have to find them, and the children's bodies were hidden. So it's not like they were just sitting there or they left them out in the open or they were decomposing where someone could smell it or anything like that. So because of their misdirection in their lies and their hiding of the bodies, that kind of explains why the children were missing for so long. Chad and Lori were also in Hawaii, so they may have been hard to get a hold of, even if people were trying to reach out to them to find their children. There could have been a point where some people thought the children were even with them in Hawaii. So there's a lot of unknowns and misdirection in that situation. Number 4, she seems pretty well organized in her planning. How can Vallow suddenly not follow along in her court case? I know the bar can be low sometimes. Sometimes too low. But I wish I could understand this one. I have a lot of questions, but I think maybe they can only be answered in an actual trial. And that's correct. What some of the facts are, we're going to learn so much as this case continues towards trial. But how can she be so calculating and plan all this and do all this misdirection yet not be competent to stand trial? As many people know with mental illness and especially competency issues, it doesn't mean that you're totally incompetent and can't do anything in life. Actually, some very brilliant people have mental capacity issues. So maybe she was lucid at the time and doing this while also believing some visions or things in her head or some ghosts or things that she thought was happening, like evil spirits and zombies and stuff like that. But at the same time, she can still plan and misdirect and do this stuff. Or another explanation for that could be maybe Chad was the mastermind around all of the planning and the misdirection and things like that. And Lori was along for the ride with, the stuff going on in her head and what she was believing or whatever's making her not competent to stand trial at this point. Question number 5. One thing that always confused me in the United States is we have a supposed right to speedy trial without undue delay. But a lot of time we see people who are arrested and their trial dates are set 6 months or even a year later. That would be a speedy trial. Meanwhile, a case like this, they managed to arrest them and they already have a trial date set for November. Is there a standard of some kind? So some cases last 5 years, 10 years even, okay? So I understand what you're saying and I get the question. The question is, I thought we had a speedy trial. Why does it take so long for some of these cases to get to trial? I think that's what this person is asking. And the answer is, we do have a speedy trial. Every state kind of has their own iteration of it. Idaho's, I believe, is 6 months that they have a speedy trial if the defense invokes that right. the defense has to demand speedy trial. And if they demand speedy trial, they have to be ready. No excuses, no continuances. They have to be ready within that time period to try that case. So most people don't know. Most of the time, in just about every case, the defense waives speedy trial. And how that happens a lot of times is the state says, we're not willing to continue it. We're not willing to do this or that unless the defendant waives speedy trial because this is going to take some time. Or the defense is asking for some documents. The state said it's going to take some time to get them, or they want to do depositions. We've got to set these depositions up. So most of the time it is not feasible or practical to have this trial take place within the speedy trial time period in most states. So most of the trials are not speedy because of the defendant's own motions or waiver of speedy trial. It's kind of a difficult situation in the law, and we don't know how to fix it sometimes because we have demanded speedy trial in cases, and you can do it later on. You can say, we're demanding speedy trial right now. The trial has to happen within X amount of days, and a lot of times that can either get deals done or bring the trial up in front of a jury sooner rather than later. Right? So that can happen, but most of the time we waive that because there's so much discovery and so many things that have to happen. You don't want to try this case without getting all the facts. If you're the defendant, you want to take your time and make sure you build the best case you can for your client because this is their one-shot deal at a fair trial in front of a jury. So you don't want to rush that process. Okay, and that's the real reason most of these trials are not done in a speedy way or within the speedy trial timeline. All right, question number 6 has a lot of things in it, but I'm going to stick to just one part of the question. Do you think she'll ever stand trial, or do you think, like I do, that she's playing like she's crazy so she doesn't have to stand trial? There are a lot of factors in place with these evaluations that are done by doctors, psychologists, psychiatrists, so that you can't trick them into thinking you're crazy. They have these formulas and lists and answers and books that show them exactly how, if people answer these ways, they are competent or they're not competent, and they can tell if somebody's malingering or lying or making it seem a certain way. So there are some protections in place that she can't just fake it till she makes it, for lack of a better phrase, so she doesn't ever have to stand trial. But a lot of times, especially in states like this that don't have the insanity defense, you're never going to be deemed not guilty. You're never going to go home free after treatment. You're going to get as much treatment as possible until you are found competent to stand trial. Or you may just be in treatment forever, which in some places is even worse than prison. So who knows? We'll see if she's ever going to have her day in court. I would be willing to bet that she will eventually have her day in court, just like Ronnie O'Neal. He was not competent to stand trial, and then eventually he was. And a few years later, he had his day in court, he had his trial. So we'll see if the same rings true for Lori Vallow. Question number 7. Can they have 2 separate trials? Chad and Lori, I assume they're asking. Can they have 2 separate trials? The answer to that is yes. 2 separate criminal defendants can have 2 separate trials, even if it's the same facts and circumstances, and they're saying they committed this murder together. So just because Chad's trial date is set this year, later this year in November, doesn't mean that they can't still try Lori later. Will their sentences be the same? So that's something we don't know. They can be the same if everything was, they did everything equally, but sometimes the sentences are very different for co-defendants in cases like this, especially if one of them was the ringleader, one of them was putting the pressure on and forcing the other one to act. That can play a big role in how they get sentenced. All right, last question we're going to do on today's show. Will you break down this trial if one happens? The answer to that is most likely yes. As long as you guys subscribe to our channel, like this video, and comment that you want to hear me break down this trial when it happens, whether it's Chad's or Lori's or both of them together. I will break it down if enough of you guys ask us to do that. So go ahead and slap a like on this video and make sure you subscribe to our page. Leave comments and questions about this case and whatever other case you want me to break down. But that's all we've got today. Hopefully you guys enjoyed it, and we'll be back with you next time. Thanks for watching this episode of The Lawyer You Know. If you like this content, please share it with your friends. Make sure you subscribe to our page and like our videos. If you want some interaction, get in the comments and we'll be sure to get back to you. If you want to know any more information about our firm or this page, you can find out in the description or visit tragoslaw.com. We post multiple times throughout the week, so make sure you hit that bell so you can get the notification and not miss out on the next episode.